Every contract begins with an agreement. Two parties sit down, talk, and try to find common ground. One side may ask, "Can we change this clause?" The other may say, "Shall we add a condition?" As lawyers, we need to describe these moments in clear and polite English. Today, you will learn how to use simple vocabulary, polite suggestions, and basic legal phrases to explain how an agreement is reached. By the end of today's lesson, you will use vocabulary like proposal, acceptance, negotiation, compromise, consensus, settlement, amendment, and final draft, and use polite grammar with let's, shall we, why don't we to suggest changes, and learn legal phrases like mutual consent, meeting of the minds, offer, and acceptance, reach a settlement, sign off terms. Practice telling the story of how two parties reach an agreement in simple, professional English. Imagine this: two companies meet to make a contract. The first company makes a proposal. "We can deliver the goods in 30 days. The second company replies, "That is too fast. Shall we change it to 45 days?" The first company agrees, "Yes, let's make it 45 days." After some discussion, both sides accept the terms. The lawyers say, "We have reached an agreement. Let's prepare the final draft." This story shows how simple words and polite suggestions help two parties come to an agreement. A proposal is a formal suggestion. It is the first step in reaching an agreement. For example, the company made a proposal to reduce the price. Imagine a lawyer sits at the table and says, "Our proposal is to pay in two parts, 50% now and 50% after delivery." Proposals open the door to negotiation. Acceptance means saying yes to a proposal. For example, the client gave their acceptance of the offer. Imagine one company offers to sell machines at $10,000. The other company says, "Yes, we accept." At that moment, there is acceptance, a key step in forming a contract. Negotiation is the discussion where two sides talk, offer, and adjust until they find terms they can both accept. For example, the lawyers are in negotiation. Imagine the buyer wants delivery in 30 days. The seller wants 60 days. Through negotiation, they find 45 days as a middle ground. This back and forth is negotiation. A compromise happens when each side gives up part of what they want. For example, they reached a compromise on delivery time. Let's look at a story. The buyer wants delivery in 10 days, the seller in 20 days. They compromise on 15. Neither side gets exactly what they wanted, but both sides can live with the result. Compromise is often the key to agreement. Consensus means general agreement, often reached after negotiation. For example, there is consensus to sign the contract. Imagine several managers discuss the contract. At first, they disagree, but after talking, they say together, "Yes, this works for us." That is consensus. A settlement is an agreement to end a dispute, often in court or before a trial. For example, the parties reached a settlement in court. For example, two companies are fighting about a broken contract. Instead of going through a long trial, they meet and agree. "You will pay damages and we will drop the case. That is a settlement. An amendment is a formal change to an agreement. For example, the lawyer prepared an amendment to the contract. Imagine the parties agree on everything, but later they decide to extend delivery from 45 to 60 days. The lawyer writes an amendment to update the contract. Amendments keep agreements current. A final draft is the last version of the agreement after all negotiations and amendments are finished. For example, the final draft is ready to sign. Imagine, after weeks of negotiation, the lawyers say, "This is the final draft. Please review it carefully. If everything looks good, we can sign tomorrow." The final draft is the version that becomes the official contract. When parties reach an agreement, they often use polite language. Three simple tools are let's, shall we, why don't we. Use let's to make a joint decision. Let's confirm the terms. Use shall we to politely suggest something. Shall we add a clause about delivery? Use why don't we to make a friendly suggestion. Why don't we change the date to Monday? These expressions keep the conversation cooperative, not aggressive. They show teamwork in reaching an agreement. Let's use these in real negotiation context. A lawyer says, "Let's finalize the draft today." This shows a joint decision. Another says, "Shall we move the deadline to next Friday?" This is polite and formal. A colleague suggests, "Why don't we meet tomorrow morning?" This is friendly and collaborative. Using these phrases make the process smoother and helps both sides feel respected. Mutual consent means both sides agree freely to the contract. For example, the contract is valid with mutual consent. Imagine, if one side is forced or tricked, there is no true mutual consent, and the contract may not be valid. A meeting of the minds means both parties understand and agree on the same terms. For example, there is a meeting of the minds about payment. Imagine if one side thinks payment is $10,000 and the other thinks it is $12,000, there is no meeting of the minds. Agreement requires clear understanding. Every contract starts with an offer and acceptance. One side offers terms, the other side accepts. For example, there is a contract after offer and acceptance. Imagine, a company offers to sell goods for $5,000. The buyer says, "I accept." The moment of acceptance creates a binding agreement. To reach a settlement means the parties solve a dispute without going to trial. For example, the companies reached a settlement. Imagine two companies disagree about delivery. Instead of going to court, they talk and agree. "We will pay a penalty and you will continue the contract." That is reaching a settlement. To sign off on terms means to give official approval before signing. For example, the manager signed off on the terms. Imagine, a lawyer prepares the final draft. The director reads it and says, "I sign off on these terms." This is the last step before the contract is signed. Let's look at a story to wrap it all up. Two companies negotiate a supply contract. Company A makes a proposal. Delivery in 30 days. Company B replies, "That is too fast. Shall we make it 45 days?" They talk, adjust, and finally reach a compromise at 40 days. After more negotiation, The managers see there is a consensus. The lawyers prepare the final draft. Before signing, the director says, "Let's confirm the terms." Everyone gives mutual consent. There is a true meeting of the minds. The parties sign off on the terms and the contract is ready. The lawyers say proudly, "We have reached an agreement." This story used today's vocabulary, grammar, and legal phrases to show the process of reaching an agreement in clear steps. Today, you learned how to explain the process of reaching an agreement in simple English. Vocabulary for the steps of negotiation and agreement: proposal, acceptance, negotiation, compromise, consensus, settlement, amendment, final draft. Grammar for polite suggestions: let's, shall we, and why don't we. Legal phrases for the principles of contract law: mutual consent, meeting of the minds, offer and acceptance, reach a settlement, and sign off on terms. And a full story to connect them together. Now, you can guide someone through the process of reaching an agreement clearly, politely, and professionally.